Good morning, everyone. My name is Boertje, and I run a commercial risk consulting business known as Boertje, servicing people, as a matter of fact, all stakeholders in the construction industry supply chain. I hold a BSc QS, and I'm a qualified adjudicator and arbitrator. I do a lot of training on the JBCC and the master builders contracts. Just to get the formalities out the way, I am not an attorney and my content does not constitute legal advice. It is my interpretation of the subject matter only. I'm very often asked the question, how do I deal with a pay when paid clause in my subcontract? And many of the participants this morning that work as subcontractors to main contractors will be familiar, I hope, with this clause that is often inserted into a subcontract. Okay. I am going to be moving fairly quickly this morning, given our time constraints. We are going to cover the reason that main contractors insert a clause like this. What does the law say about it? The requirement to do due diligence on your debtors, the necessity to get your work certified, remedies for non-payment in the main contract, the contractor's obligation to secure payment from the employer, and I will give you some tips on risk mitigation when you find yourself in a situation where you have to deal with a pay when paid clause. Let's get straight into it. Okay. Why do main contractors insert a pay when paid clause? It's all about cash flow. Subcontract scope normally makes up 60 to 70% of a main contractor's cost on a construction project. So long gone are the days where a contractor has a large internal set of skills and a big staff and labor complement. Long gone are those days. Everything gets subcontracted. Also, all to do with cash flow. Contractor can't keep a big workforce waiting for the next job. Is not paid, okay, it will be now impossible for him to fork out 60 to 70% of his month's cost to all of the subcontractors. Okay, so that is why that clause is put in there. It's to save main contractors from a cash flow catastrophe. And from their point of view, you can understand why they do it. Okay, so of course for subcontractors, the converse is true. They are faced with a cash flow shortfall if they're not paid timeously. And I'm sure that down the line, subcontractors have got their own obligations at month end in terms of all of their suppliers and labor and staff. Perhaps you're getting settlement discounts at month end, etc. So, subcontractors find themselves in the same situation or worse. So how do we get around this? Well, it is difficult, let me tell you that. Okay? A pay when paid clause typically is a provision that trumps all other provisions dealing with payment. Okay, so the JBCC and the master builders and many other what we call standard form agreements have payment provisions and processes defined in them, and then a contractor will have a special set or a set of special terms and conditions, and in there will be the pay when paid clause. Okay, and it does trump all of the other provisions normally. You will often see in a subcontract that the contractor lists the contract documents in the order of precedence that they are to be interpreted, and their special terms and conditions are normally right at the top. Okay. Simply put, the pay when paid clause says if the employer or client does not pay the main contractor, then the main contractor is not going to pay the subcontractors until such time as that payment has been made on the client. Okay. Of course, in the current environment, where contractors and subcontractors are making very small margins, in my opinion, this puts a lot of pressure onto the system. What does the law say? Okay, so in the law in South Africa, it comes from Roman Dutch law, but there's a lot of stuff that happens in the UK that ends up filtering into our law, and I suppose that's got something to do with the Commonwealth. But quite a long time ago now, I think it was in the early 2000s or even earlier, okay, the United Kingdom introduced legislation, okay, that outlawed pay when paid clause. Okay, so in the UK, any pay when paid clause that's inserted into a subcontract is deemed null and void by the court. Okay, and we haven't got time today to explain what that did in the UK and how people and businesses had to start doing business differently, okay, to protect themselves from that. There have been moves afoot in this country to introduce legislation. You know, I remember going to a talk about 5 years ago on it. There's some legislation called the Prompt Payments Regulation, and it has simply just been stalled for years. And possibly that's because that legislation would apply to government and public entities as well, and state entities. You may find they are not able to abide by that legislation. Yeah. There's also a school of thought that says that pay when paid clauses are unconstitutional. Okay, so since the advent of the Constitution, there's a lot of all legislation and all private contracts, okay, have to comply with the legislation, should I say. And there is a school of thought, and they're possibly correct, that pay when paid clauses are unconstitutional and they should be struck from subcontracts. Okay? You are hardly going to approach the court on these grounds when you are not paid. Okay? I'm sure you're familiar with, or you hear about it, or maybe you've experienced going through a litigation in the courts. It is a very long and time-consuming process. And normally, you want to get things resolved ASAP. So I don't know anyone who has approached the court regarding that. Okay. So for practical purposes, and certainly for the time being, yeah, please assume that pay when paid clauses are legitimate and a contractor can rely on them to delay payment to a subcontractor. Okay, due diligence on your debt. My advice is that before accepting a pay when paid clause, you need to do some due diligence on your debtors. Okay? For example, establish who the employer is and their track record as a developer. Remember, we are dealing with pay when paid. We are not dealing with a contractor's breach of payment. Okay, we're not dealing with the scenario where a contractor has been paid and then he hasn't paid you. Okay? That's a different subject. So who is the employer? Because that is ultimately the person that you are taking the risk on. Okay? Be wary when working with new contractors and employers. Okay, you see developers popping up all over the place. They might do one development, fly by night, they're off. They might not have enough equity, and etc. So, you know, who are these people? Have you worked with this contractor over the years? Does this contractor do his own due diligence? And you can ask these questions to a contractor. You know? Check if the contractor is getting an advance payment. Okay, maybe you can also get an advance payment. Okay, check if the contractor is waived its lien. Okay, so very briefly, a lien is a common law entitlement to maintain possession of a property or a site if you haven't been paid. Okay, and 99% of the time, this is also taken out of main contracts. Okay, because employers and banks do not want contractors holding onto a property because they haven't been paid. But all of these things stack up as risk, so you need to know if he's waived, if they've waived any. Is the employer providing a payment guarantee to the contractor? Okay, so if a contractor has waived his lien and he's not allowed to maintain possession of the property if he hasn't been paid, when I say that, I mean lock the gate. The employer can't come in. Okay, you might be building a complex of houses and 98% complete. If you haven't been paid and you haven't waived your lien, you can lock the gate lawfully and not let them in. Okay? Check what the main contract terms of payment are. So is the contractor getting paid in 7 days, 14 days, 30 days, 45 days? What is it? Because if the payment terms are short, you can deal with it quicker. Okay? So otherwise, you're going to be in for maybe 2.5 months of work before you realize that the previous certificate hasn't been paid for. Okay. Check if substantial changes have been made to the wording of the subcontract agreement. You are allowed to ask questions. Okay? There's no need to enter into subcontracts blind. Okay? So if a contractor gives you a tender inquiry to price, and for example, it says all the terms and conditions of the main contract apply and they're available for perusal at our office. You tell them, no, I'm not coming to your office to look at them. You must send them to me. I want to read them. I want to see about liens and payment terms and payment guarantees, etc., etc. Okay, so there is certainly some due diligence you can do. Don't just sign a subcontract with anybody and any employer. The necessity to get your work certified. Now, this is of critical importance. Okay. You have to get your debt liquidated. Okay. Now, a liquidated debt is one that is due and payable with no underlying dispute or other factors causing the payment to be challenged. Okay. So a liquid document in what we're talking about today will be a subcontract payment advice. Okay. So if you're contracting under the JBCC or the MBSA, and that's essentially what we're talking about today. Okay, make sure that at the end of the month, you get a subcontract payment advice that clearly stipulates exactly how much money you are going to get paid. Okay. You need this for a variety of reasons, which is beyond the content for today. But one of them is that if the contractor does not pay you, but he has been paid, okay, he's got no defense to your subcontract payment advice. Okay. There's no argument about how much you owed, and you can use that document. Yes, you might also have to go to court, you might have to go to adjudication, whatever, but you have a document that says the contractor owes you an undisputed amount of money. Okay, so please, regardless of whether you have a pay when paid clause or not, okay, please make sure that you always get a document that certifies how much money you are owed for a particular month. Okay, so just some tips around that. Pay attention, okay? Submit accurate valuations for payment. So don't expect a contractor to give you a wonderful subcontract payment advice if you put garbage into the system, okay? Make sure you submit a proper valuation. This is how much work I've done. This is my material on site. And this is how much I want to be paid. Okay, then you can assess your valuation for payment properly and issue a subcontract payment advice. Okay. Like I've said, there's no defense to the non-payment of a subcontract payment advice, okay, except for hiding behind the pay when paid clause. Now, of course, if there is a pay when paid clause in operation and payment is delayed, once payment is made, assuming it is made, you don't want to then be going around trying to work out how much you are getting paid. Okay, you want the subcontract payment advice to say, right, the employer is paid, you owe me X amount, pay it immediately, I don't have to wait. Okay. So by doing the above, you will have protected yourself from a payment breach by the contractor, okay, and not occasioned by a payment breach from the employer. In most instances, if you have a subcontract payment advice and you're not paid by the contractor, and the contractor has been paid by the employer, okay, you can normally suspend the work. Okay, and we're going to come to the remedies now. Okay, you cannot suspend the work. You cannot walk off site if you haven't been paid. Okay, and you're on a pay when paid clause. Okay? Just remember that. Okay, a lot of people say to me, "Haven't been paid, I'm leaving." That puts you straight away into your own breach of contract. Yeah, you signed a contract that said you accept that you're only going to get paid after the contract is paid. If you then decide to leave site, okay, you're going to be in breach yourself. All right. Okay, so all of the standard form agreements have remedy for late or non-payment. Okay, so in the main contract, okay, the contract between the employer or the client and the contractor, there are provisions for default in payment. For example, the contractor is allowed to lawfully suspend the work. Okay? He's got to put the client on notice first, which seems a bit obvious, but that's how it works. You know, Mr. Client, you haven't paid me. You've got X amount of days, and not a lot of days, 3 to 5 days, depending on which contract. If you haven't paid me by that date, I'm going to lawfully stop working. Okay, you are going to owe me an extension of time, so I'm going to get given more time to do the project. Plus, I'm going to submit a bill for that, and you're going to have to pay it. Plus, you're going to give me interest on late payment. Okay, and if you still don't pay me after all that, I am going to terminate the contract. Okay, which means I have got no more obligations to perform. But guess what? You will have all the obligations still to pay me. Okay, so it's quite powerful, those provisions within the JBCC. Okay, so make sure that those things are not taken out of a contract, of a main contract. Okay, under no circumstances can you take away these remedies, plus waive your lien, plus not get a payment guarantee, etc. Okay, I would never contract under those circumstances. You've got no remedy when the employer doesn't pay. Now, what often happens is that contractors don't do enough, okay, to secure payment. Now, a contractor cannot do nothing. Okay? He cannot sit and tell you for months on end, well, I'm sorry, you haven't been paid, I haven't been paid, therefore I can't pay you. Okay, so tough. Doesn't work like that. Okay? He has an express, implied, or tacit obligation, which means either it's in the contract, either it's implied from the contract, or from the law, common law, okay, that he has to secure payment from the employer on behalf of himself and all of the subcontractors. Okay, so a contractor can only hide behind that clause when it is administering the contract properly. Okay. Of primary importance, when payment is late, contractor must issue a notice to suspend. And I've recently been involved on a contract where the November 2021 payment certificate was only paid in March. The main contractor decided not to suspend, okay, and he had untold issues from the subcontractors. And he ended up dealing with extensions of time, claims for money, claims for interest, etc. Okay, because he did not suspend the work when he ought to. Okay. Of course, if a contractor suspends and he still doesn't get paid, he needs to terminate. Now, why would you want to continue with a contract, regardless of what it does to your order book, if you're not going to get paid? And you're probably going to end up closing your company. So the urge of contractors who have got a full staff complement and a whole lot of plant on site is, oh, we need to keep working. We don't want to get into breach. Let's just give this employer more time. It's okay. We'll carry on. It's not okay. Yeah. If you're not paid, contractor needs to issue a notice to suspend. Okay. And the same goes for a subcontractor. Yeah. If you haven't been paid by a contractor who has been paid, you immediately issue your notice to suspend. If you suspect that the contractor is not taking the necessary action, okay, get involved. Ask the contractor, please can you send me your letter of suspension? I want to know what date you put the employer on suspension. Okay. Okay, I've actually handled this slide already. Okay. Just remember that if you are going to put an employer or a contractor on terms, okay, i.e. issue notices for suspension and termination, etc., it's always best you get a little bit of professional advice from people who know about the JBCC and the MBSA, because if you get it wrong, you can find yourself in breach, or worse, you can be accused of repudiating your contract. Okay. Here are some mitigation measures in conclusion this morning. Make sure you have excuse me, short payment terms. Okay, so there's no point having the contractor on 30 days and you on 30 days, which is 60 days. None of the standard form agreements, except for FIDIC, have ridiculous payment terms like that. It's 2022, cash is tight, cash is king. There's no such thing anymore. Okay? The entire payment cycle should never be more than 28 days. Contractor paid and subcontractor paid. Okay? It is becoming more and more common to ask for an advance payment. And yes, you may have to provide a guarantee to get that advance payment. You can price for the cost of that guarantee in your tender. Okay? And that guarantee only guarantees that you will pay back the advance through the certification process. So there's no risk on that guarantee. Okay? Ask if you're fortunate enough to get a deposit without a guarantee, try and get it. Cash on delivery, sometimes that's possible. Payment guarantee, 99% of the time you won't get a payment guarantee from a contractor, and that's simply because they cost too much money and they tie up too much cash and collateral. So a main contractor cannot go out handing payment guarantees to the entire supply chain. As I said, manage the valuation process and issues as they arise. Keep to formalities. There's a reason you sign a contract or a subcontract. Hopefully you never have to bring that subcontract out, okay? Because you're going to get paid and the project's going to go well. More and more often these days, I see the contract coming out all the time, okay? So keep to the formalities in the contract. Not mandatory, but try and get originals of your subcontract payment advices. I found these days that the courts do accept electronic copies, okay? But still not a bad idea. If you have an original that's signed by the contractor, maybe it's got a stamp on it, there's no doubt whatsoever that they issued that. Right? Please don't make verbal agreements. Okay? There's no such thing as a verbal agreement in the JBCC. There's no such thing as a verbal instruction. Okay? If you make verbal agreements, you're going to find yourself in a position where two people have a different interpretation of what you agreed. Okay, don't leave things to be interpreted by attorneys or people like me when they can be easily written in clear English. Okay? Perform properly. Okay? Don't give the contractor or the employer an excuse not to pay you, okay, or an excuse to put you on terms. So perform properly. Okay? Credit insurance is available through people like Credit Guarantee and a few others. Okay, also not a topic for today, but if a contractor is in good standing, it is very possible that you can get credit insurance on the contractor. So if they don't pay, you can claim from the insurance company. Okay? Check about the lien and whether it's been waived, and do that due diligence for risk assessment. prior to working. And remember, it may be a contractor that you've worked for on many occasions. Who is the employer? Make sure you know who that is. Okay, and that brings us to the end of my session. And we've got a few minutes for questions. Thank you, Byron.
Just a big thank you to Brad for coming in on the early morning. I don't think we're going to have any questions, so I'm going to end off the session. So thank you very much for coming in this morning. I hope everyone has a blessed week and have the best week possible. Goodbye.
Okay. Thanks, everyone. Bye.